Recording in progress.
Hey everyone, we'll start in just a moment. Hi, Travis. Nice to meet you.
Hello.
Good to see you. I think we have folks still trickling in from the waiting room. I'll just give it another few minutes here and we will jump right in. All right, well, why don't I kick us off? Welcome, everyone. My name is Andy Grotto. I direct the program on geopolitics, technology, and governance at Stanford University, the Cyber Policy Center, which just a few days ago, we announced an exciting development in our institution's place on campus. We are now a joint initiative of Stanford Law School and the Freeman Spogli Institute for International Studies. 3 weeks ago, President Biden signed into law the Cyber Incident Reporting for Critical Infrastructure Act. The law requires owners and operators of critical infrastructure to report certain cyber incidents to the Department of Homeland Security's CISA, the Cybersecurity Infrastructure Security Agency, within 72 hours, and ransomware payments within 24 hours. The law will take effect once CISA promulgates implementing regulations. This is the latest entry to the growing catalog of cybersecurity-related laws and regulations at the state and U.S. federal level, as well as internationally. The SEC alone right now has 2 rulemaking activities underway on cybersecurity, one focused on advisors and funds, the other on public companies. As policymakers and at the state and federal level continue to search for the right balance of collaboration and enforcement, we've brought together a stellar lineup of experts to offer a perspective on the evolving legislative and regulatory landscape for cyber risks. So joining us is Travis LeBlanc. Travis is the vice chair of the cyber data privacy practice at Cooley, and the Senate confirmed member of the U.S. Privacy and Civil Liberties Oversight Board. He has guided leading tech companies through enforcement proceedings and class action lawsuits. Alicia Lowy-Rosenbaum is vice president and associate general counsel for cybersecurity technology and trust at Salesforce, where she provides strategic counsel on risk management and governance to the company's security, engineering, and operations teams. Jim Dempsey, my colleague at the Cyber Policy Center, is a senior policy advisor for the program I lead, Program on Geopolitics, Technology, and Governance. He is the author of Cybersecurity Law Fundamentals, a handbook for practitioners, published at the end of last year by the International Association of Privacy Professionals. I am going to drop a link to the book in the chat. It's an amazing book, the only resource out there that I've seen that collects U.S. cybersecurity law, puts it in one place with Jim's expert and experienced eye providing an overlay of coherence and analysis. So with that, let's jump in. Alicia, maybe I could start with you. From an in-house perspective, what are the types of cybersecurity challenges that you're facing? What's keeping you up, keeping you occupied?
I would have to say, you set forth you and I often talk about sort of what's keeping me up at night, but central to this is the regulatory framework and its changing, ever-changing landscape. And with the proliferation of what we're seeing around the world and the absence of regulatory harmonization, how do you approach operationalizing against all these disparate standards, right? We're seeing, you mentioned critical infrastructure in the US, we're seeing it in the EU, in APAC. Really trying to be responsive as a good corporate citizen and a conscientious member of the cybersecurity ecosystem, with partnering and sharing of incidents and the related remediations, and really having that partnership with CISA, now the SEC and other regulatory bodies, but also figuring out how to keep the lights running from a cybersecurity perspective, right? My number one job is to keep the platform safe. That is a big job for all the people that are involved with it. But now we have to really think about a thoughtful muscle for all of this reporting that may be required.
Yeah, that's right. Travis, from your perspective, what all this activity around incident disclosure, I mentioned the federal legislation. What is your outlook on where this is headed? There's a lot of debate about, for example, in the federal legislation that the president just signed a few weeks ago over what entities should be covered, what types of incidents should be reported, including whether or not there should be, a severity threshold. Based on your counseling of a diverse range of clients, what is your outlook on sort of what some of the right or appropriate answers are given the government's interest in gaining more insight into the cyber threat landscape?
First, a great question. First of all, thank you for the invitation. It's always a pleasure to see Jim, to see Alicia here. What you left out of my bio is that at the Privacy and Civil Liberties Oversight Board, I actually occupied Jim's seat. Used to be Jim, and I took over for Jim. So it's a high five.
It shall henceforth be known as the Travis LeBlanc Chair.
There you
go. But the question that you asked, which is sort of, what am I seeing across a lot of industries, at least when it comes to thinking about cyber? And I actually want to step back for a moment and go back several years and note that we've been having a conversation around convergence. And essentially, every company is kind of a tech company now, every single one. We all know that. That's no surprise. Literally, every company out there is a tech company. You have an online presence. You are, a lot of your operations are either, organized digitally, they're marketed digitally. Every company to some degree is a tech company. And I think that now means that every federal agency, to some degree, has a role now in technology regulation. I'm going to just say tech. And we can take that to cyber. That we can go quickly to cyber on that in realizing the alphabet soup of agencies that all now play a critical role in cyber. Whether you traditionally see it as the FTC or the FCC, kind of the consumer protection ones, you can see now the writings, you clearly have the SEC, multiple rulemakings are ongoing around cyber. You have CISA. We have a national cyber director that will have the authority to promulgate regulations. I think I saw Jim Halpert on here, new general counsel to the NCD. I imagine Jim will be taking a keen role in promulgating regulations in short order. At least they have the authority to do it. We'll see if they do it. And so I think the CFPB is clearly on the horizon. I mean, the CFPB has started to lay its oar in there. So I think we're out of, and after, believe it or not, TSA, which is part of DHS, but TSA actually oversees pipelines. And because of Colonial Pipeline, you've got TSA that's involved, and the list goes on. And I think what's happening now is all of the agencies are realizing that they have to take some ownership of not only their own InfoSec practices, but also of the industries that they regulate. And the question that we get again and again is, who's in charge? Who is it that's actually deciding cyber policy for the United States? Is the left hand talking to the right hand about these issues? And that, I think, is what's causing a lot of concern, because when you're a company in the middle of a breach, for example, you may be dealing with the FBI. And very soon, you're going to now have to report that. In an AK. And what if the FBI is trying to do a law enforcement investigation and there's no exception for any of this? So I think we're at a point now where the industry ultimately would benefit from having consistent, more coordination across the federal government, including independent agencies. Is not to say that each one shouldn't be doing anything. It's more to say we want to make sure that everyone is talking to each other.
That's a big challenge vis-a-vis the independent regulatory agencies. Before coming to Stanford, I was the senior director for cyber policy at the National Security Council, where a big part of my job was to coordinate this activity across U.S. critical infrastructure. And just pick the financial sector alone, we have more than a dozen regulators who have some slice of the landscape at the federal level, let alone, when you start talking about state insurance regulators, state financial regulators like the New York DFS. And, we have independent agencies for a reason in statute, right, to preserve their independence. But yeah, you're right. It was this, and I suspect it's still a case, this struggle to try to encourage harmonization. Jim, you just wrote a book on cyber law. What is your take on this problem? I mean, is there what is the answer to this coordination problem? Is there an answer?
I wrote a book, and between the time I sent it off for layout and page proofing and the time it was published, I ended up with, I think, 40 single-spaced pages of updates to the book, which I promptly published on a website that I created, cybersecurity-fundamentals.com, and I've continued to update that page. But I think Alicia and Travis have both pointed to this problem of harmonization. It is a patchwork. And as Alicia said, it's a three-dimensional patchwork in that you've not only got the complexity at the US level, federal, state, multiple federal agencies, you've also got the international piece to this. I think there are 2, 3, maybe 4 themes that can be called out here in terms of why things are getting so complicated. One is, just in the past year or so, a shift from a focus solely on personal information, sort of data breach, the traditional Home Depot, Target, Equifax, Anthem Health data breach of personal information. That's still very important. A shift from that, though, to include and expand critical infrastructure and operational technology. You see that in the federal incident reporting law, which is not a federal breach notice law. We have all 50 states having breach notice laws on personal information. The federal law is focused on critical infrastructure and incidents that affect the operation there. The banking regulators recently put out a final breach notice rule for regulated banks, which covers personal information, but also covers anything that materially disrupts the operation of the bank. The SEC has a proposed rule on public notice. The new legislation is not a public reporting law, and you don't report to the victims, so to speak. It goes to CISA and actually is intended to be kept within the government. The similar for the bank regulator rule, the SEC rule is a public reporting rule. But again, it goes beyond just privacy type breaches to include operationally disruptive. Second big thing that I see going on here is this shift from the traditional emphasis on public-private partnership, which has dominated US cybersecurity policy for 20 years or more now, to regulation. You saw that spill over just, I think it was yesterday or the day before, on the Hill. There was a hearing in Congress as to sort of what's the next step in terms of legislation. focused on these critical infrastructures. The Republicans, or at least the Republican ranking member on the Homeland Security Committee, wants legislation that would force the administration to be more specific in defining what is a, blanking on it now, systemically important critical infrastructure. Since everything at some levels of critical infrastructure, we need to now focus it. And the ranking Republican wants to just get that definition. Chairwoman Clark says, no, I'm not satisfied with just defining it. I want to regulate it. I want to say, what is it that they need to do? And of course, we have the pipeline security reg issued by TSA after the Colonial Pipeline incident. We see the FTC announcing at least an intent to regulate. I don't think, and this is, we can dive in on any of this, but going to Travis's point, in a way, what Alicia was referring to, I don't think we're ever going to get full harmonization. I think we're always going to have a sector by sector approach. I think at some level it's unavoidable to have a sector by sector approach. But it is true, as Travis suggested, you know, the Congress passed one law on breach reporting with 72 hours. 2 days later, or 3 days later, the SEC proposes a rule for breach notice with a different time frame and a slightly 4-day reporting and a slightly different definition of what's a reportable incident. And you know, the banking regulators have their rule, and it's entirely possible that some entity will be subject to all three.
Right. Well, yeah, let me put this position now, because, you know, Salesforce, a lot of Salesforce's customers are in, you know, span these sectors. So what are Salesforce's customers demanding in terms of insight into, you know, how a company like Salesforce protects, obviously, you know, first and foremost, their data, but also their exposure to regulatory risk?
You know, I think they're really trying to take us up on the notion that we're partners with regulatory compliance, right? We have the shared responsibility model where we partner with our customers to enable their compliance. Very much in parallel, I think they're relying on us to be thoughtful corporate citizens and work with government to try and achieve some achievable results around some of this legislation, and really have conversation through our trade associations and you know, folks in and around the Hill or in other parts of the world to give thoughtful comments back. As you mentioned, the SEC guidance is just it's in draft form, and they're inviting comments to really say, what are the practical implications on behalf of our customers, right? Because this is going to create a lot of noise, especially as Jim said, incidents have been expanded to availability, what we call availability incidents, which happen a lot, and without further definition about what's the right fidelity that the government would like to hear about, they're going to get a lot of information. It's going to be a lot of noise is what I'll call it. How do you separate the wheat out from the chaff? So,
Alicia, could you elaborate a little bit on what you mean by availability, just for those in the audience who may not be familiar with that distinction?
Sure. So what we're seeing is, as Jim was noting, is a trend. So traditional incidents are when your data, there's unauthorized access to it, it's been altered or taken out, and here it's a little bit different. You as the customer, you as the data owner don't have access to it. So your system can go down. That could be triggered by a ransomware attack. That could be triggered by a DDoS attack. It could be you pushed some code that did a catastrophic change management. So you've got to roll it back, and that takes time. Really getting some detail from the government about what they really care about. So stepping back, they want to know for these critical, what Jim called these systemic critical infrastructure products, what's the impact on the country if everyone can't get access to X? Or what's the impact on shareholders, Salesforce shareholders, if our customers can't get access to their data? And as Travis was mentioning, their business is very heavily reliant. That's the end goal. And I think based on so many different lenses and the fact that all the different rubrics overlap, it's very difficult to figure out a path forward that's just not super inclusive of a lot of different standards. I don't know, did I answer your question, Andy?
Yeah. Yeah, and there is this sort of call it legal philosophical question of whether a sector by sector approach, the sort that we have taken historically in the United States on these topics, compared to the sort of the baseline setting model that the Europeans have used. You think about GDPR and the Cybersecurity Act and others. I'm curious if any of you have a view, just based on your experience as practitioners, as close observers of the cyber law landscape. Is it obvious? Is one of those two approaches better or worse, or is it apples to oranges? Jim, why don't we start with you?
My own view, Andy, is, at least in the United States, we're stuck with the sort of crazy quilt. Partly, of course, because we have a federal system. We have the 50 states. 23 of those states already have a law that says that companies that collect personal information on residents of that state must protect it with reasonable security measures. Open question what reasonable means, except in California. Travis, were you working for the vice president when she was attorney general? She issued a statement basically pointing to the Center for Internet Security top 20 list and saying, okay, that's my interpretation of the California interpretation of reasonable. Most other AGs didn't do that. So you've got the states, every one of which has a mini FTC Act, which also covers either deception and or unfairness. And, we've got already a pretty deep regulatory structure for the bulk electric power system through Federal Energy Regulatory Commission. We've now got these pipeline rules. And at some level, you've got the Gramm-Leach-Bliley rules for the banking sector. You've got the HIPAA rules for that HIPAA bubble entities under healthcare. So I don't know, I'm resigned. And you've got a gridlocked Congress. So I'm resigned to this approach, and it forces Alicia, it forces Travis, it forces every practitioner to have some kind of grid, either on a chart on their desk or in their mind, to have this grid where they're constantly looking across these overlapping requirements. And then you have to develop, in the case of Alicia or Travis and representing his clients, you have to talk about what's the enterprise-wide strategy. But that's what companies have been doing on privacy for a long time now.
Right.
On the three dimensions, state, federal, and international. And now they're having to do it on cybersecurity.
I'm with Jim in the sense that I think it is now in the DNA of our federal regulatory system that we have sectoral, regulation. And I don't think that's likely to change. However, that being said, what we're mostly seeing coming out of the federal government, mostly, not 100%, but mostly seeing, really goes to transparency. It's a number of different regulators all trying to push more transparency about the side of industry. And you sit in different flavors. So it is correct that you could have multiple regulators that are all asking for different timelines. They're not largely all asking for wildly different information about everything. It is largely consistent. Again, not overarchingly consistent. What I would like to see, recognizing that we are going to have a sectoral by sectoral approach, is a central coordinator at least the federal level that maybe is occupying a role kind of like OMB, would do with new regulations coming out and thinking about them and catching inconsistencies between them or spotting conflicts. I do think some coordinator at the highest levels would be useful. And whether that can be done at NSC or not, I will leave for others to decide who is right for that. But I think ultimately that is going to be really important for us to be able to have unified cyber strategy. And frankly, for agencies that should be, if we're going to adopt a sectoral regulatory regime, and there are some agencies that aren't stepping up to the plate and issuing regulations in the right way, that coordinator, wherever it is, could also be helpful in getting those agencies to focus on cyber too.
Yeah. Well, let me come back to you with a question about you represented Zoom in its 2020 enforcement proceeding before the FTC. What were your takeaways from that case and other FTC cases you've handled? The FTC, we see this reasonableness concept in earlier FTC jurisprudence is now come under some question as a result of the circuit court's ruling 2 years ago now. Would love to hear your takeaways on the Zoom case and beyond.
Sure. So I'll start with the FTC's credit. To the FTC's credit, they moved reasonably quickly in that investigation. Historically, I think one of the challenges of the FTC's investigatory processes, it can be really slow. And slow could mean that, incidents that took place in 2019, 2018, they're finally getting around to taking action on in 2022. And we all know, certainly Alicia knows more than anyone, how different the business is, how different the threat environment is in 2022 than 2018. And what was reasonable in 2018 is not going to be the same thing that's reasonable in 2022. And so if the FTC is going to be an effective regulator in data security, it's got to move quicker. And to Zoom's credit, to the FTC's credit, at least in Zoom, they moved pretty quickly, identifying issues that really came to the foray of the world in 2020, and were already taking an action by the end of 2020. And that is historically insanely fast for the FTC. I think the reality is the commission has not been all that active as a data security enforcer in the last few years. In fact, the last several years. And that's due to a lot of things, not the least of which is that currently it's a 2-2 commission. We were the last order that came through on the sort of at the very end of the Trump FTC, but it's 2-2, and that's going to slow things down when they're trying to take action. There's also been turnover at the staff level at the FTC. The head of the privacy unit, Manisha, left earlier this year, and several of the more senior attorneys in the privacy unit, DPIP, at the FTC have also changed. I think at the leadership level of the FTC over the last, at this point, 5 to 7 years, has largely been focused on antitrust. And the expertise, Alvaro Bedoya is going to join. He's an expert, hopefully if the Senate, confirms him. But he is a privacy expert, whereas by and large, the others are antitrust experts. And the agency's efforts most publicly seem to be focused more on antitrust than frankly on privacy and security. I think, what we saw in Zoom was the beginning of the FTC really learning from LabMD about reasonable security and understanding that they needed to be more prescriptive because ambiguous requirements in consent orders may not be enforceable, and left too much room for interpretation by others So that's definitely now more apparent when you look at any of their decisions. There's also certain non-negotiable provisions that are the same in every single FTC consent order that you saw that are in Zoom. When we were doing Zoom, the AMG case was going before the Supreme Court. It's a big change to the FTC. So for those that aren't aware, there was the AMG Capital case, which was decided in the summer of 2020, I think, in which the Supreme Court held unanimously that the Federal Trade Commission lacks authority under Section 13B of the FTC Act to secure consumer restitution. So historically, the FTC has primarily relied upon an interpretation of Section 13B that would allow it to require companies to make payments into consumer redress funds to make consumer monetary relief. And the Supreme Court said they didn't have that authority, at least under Section 13B. That gutted really the main tool that the FTC has used to actually obtain monetary payments from companies that are not under a consent order and that are not being penalized under an existing FTC rule, such as the safeguards or like a COPPA, for example, where they can actually get penalties. Which means now the FTC has to, rethink and has been, it looks at least as if they're going to rethink where they're going to spend some of their energy when it comes to privacy and security, not just on the enforcement side, but also on the rulemaking side. And I think Jim referenced that the FTC in December issued a notice that it is considering initiating a rulemaking under Section 18 of the FTC Act to curb lax security practices, limit privacy abuses, and ensure that algorithmic decision-making does not result in unlawful discrimination. So there may be another rulemaking coming in the near future. If they do a rulemaking, they then can use, I believe it's Section 19 of the FTC Act to obtain monetary relief through a district court action. So that's a way for them to to go through the front door on getting monetary relief that has been taken away under Section 13B, unless Congress decides to ultimately, give them Section 13B authority, revise it to allow them to seek monetary relief. And so there's a lot of activity going on at the FTC. I think what I take away from it is part of their resources now are being devoted towards rulemaking and being taken away from enforcement. And we're not seeing a lot of enforcement activity. And frankly, as long as it's 2-2, that's not entirely surprising to me.
Andy, I agree with obviously everything that Travis said. I want to add, we did have one recent cybersecurity case from the commission against the owners of Cafe Press. And this was, I think, the first settlement in a cybersecurity case in over a year. And a couple of interesting things came out of that. One, they did manage to get a small monetary payment, notwithstanding the AMG Capital case. Cafe Press is a relatively small entity, so it's a relatively small monetary settlement. Secondly, following the lead of Commissioner Slaughter, the commission took what had been a cybersecurity case and added to it a privacy element. And part of the order is that the company going forward must minimize data collection. I think that's the first data minimization order that the commission had ever ordered. They had ordered data minimization on the disposal side, but not on the retention side, but not on the collection side. Third, though, once again, we see, as Travis said, there's this core in the FTC settlements. There's this core that's been there going back 20 years to Eli Lilly and their very first cybersecurity cases. The settling company agrees to adopt the comprehensive plan, to designate a senior officer to be responsible for it, to do a risk analysis, to develop controls responding to the risks identified, and to assess and monitor the plan going forward. Those are sort of the standards. The thing that really I find less satisfying in the FTC approach is this somewhat varying list from case to case of the technical measures that they impose on companies. After LabMD said, after the Fifth Circuit in the LabMD case said it's not enough to just tell people they have to be reasonable, you have to be more technically specific. And something that Travis said triggered for me, it really seems to me that they should have this baseline of technical measures and then customize it case to case. As it is now, it seems to me that it's customized and varies somewhat from case to case. And that leaves people like Alicia looking at these complaints and looking at these orders and saying, well, you know, they required them to do that. Does that mean I have to do that? And if I don't do that, will I be unreasonable? Will I be engaging in an unfair practice? And that list is now, I don't know, probably 50 or 60 different items that have been required in different cases of different people, of different respondents. And that puts people like Alicia in a really hard spot. Does she have to now do all of them? And by the way, even if she does all of them, and then she suffers a breach, and there's yet another flaw that the bad guys managed to exploit that had never come up in a prior case, she could still be told by the FTC, you should have done this one that no one ever thought of before.
Jim, I'm sweating. It's so true. If I had my Oura ring on, which I don't, every time Travis said enforcement, my blood pressure shot up because you nailed it. It's the complexity. How do you frost this cake? How do you navigate this? What's reasonable security? That's really my job. And so I don't feel like the divination teacher at Hogwarts reading tea leaves. What can we get our teeth around so that we can, because of course I'm worried about enforcement. I'm worried about a look back that we didn't take reasonable measures to secure the data. And I really appreciate the way that you frame that with the complexities and the nuances and the scale required by all of the important government stakeholders that Travis laid out, the alphabet soup of folks that have a legitimate interest in securing data and having these conversations. It really becomes very challenging operationally. And I'd love to ask you, Jim, Andy, and Travis, so for the last month, my team spent a lot of time trying to be very thoughtful about the Russian and Ukrainian war and how do we operationalize sanctions. And as you can imagine in a cloud environment, it's really interesting. Even the law is not, wasn't until recently applicable to cloud service providers. So it says, cease doing business with Jim Dempsey Inc. And, the regulators think that we can sort of just unplug you from your data. And it didn't really match the regulatory framework. And so that we needed to have conversations about what that meant. And I think unlike privacy got way out ahead of us. The regulators have gotten more sophisticated over the past few years. I think cyber has to catch up and we have to have these rich conversations about operational reality, mapping sort of the theoretical framework and having those rich conversations. And so any advice about how we approach that? Is this cohort up for having those conversations around education? And we talk about public-private partnership, but this is really what industry needs, is thoughtful conversations about reasonableness.
Well, you raised two related questions there, Alicia. One is the sanctions question, and that brings a whole other agency into this, which is Treasury in most cases. And overarching that is one of the other major trends in cybersecurity law and policy in the past year or so, which is the growth of the national security piece of this. Again, going back we were talking about cyber criminals. We were talking about credit card theft and things like that. Data that could be used for identity theft and financial fraud by criminals, some of which were state-sponsored or state-affiliated, or certainly in the case of the Russian group, the state was allowing them to operate. But now, and increasingly, obviously in Ukraine, puts a very, very fine point on this. Companies are having to look at cybersecurity not only through the data breach lens and the criminal lens, but through the national security lens. My own feeling is, just knowing to the limited extent I know the agencies involved, they are quite, I think, open to walking through these things and discussing them, because they know that they are putting a challenge on companies. Ransomware, for example. Basically, I think the advice from the government has been, we would prefer you didn't pay, but we know it may be a business necessity, or it may be desirable from a business perspective, almost a business imperative to pay. Better to talk to us first. Travis, you're shaking your head, but you're the one really there taking the phone calls from companies. It seems to me the advice should be, you've got to talk to your regulator. Don't like ignore them or pretend they don't exist or think you can keep something quiet. Better to ask for, if it's a ransomware, excuse me, better to get in there and alert the FBI. Maybe even ask the OFAC for guidance on a particular payment. But sticking your neck out, is that, what's the trade-off there?
Yeah, so I was shaking my head because I actually thought you were summarizing the U.S. government position accurately.
Yeah.
A lot of people think the U.S. government's position is just don't pay. And you cannot pay, right? It's actually, we discourage you from making the payment, but we understand it's a business decision. And if you're going to make the payment, then, coordinating that payment with the Bureau, the FBI or Secret Service or whatever agency you're working with at the time, is the kind of factor. It's a mitigating factor should you make a mistake, right. And pay someone that is on the sanction list. I do think that for most companies, there's been a little confusion in the last year or so about their ability to recover ransom payments that they make, because they heard that Colonial Pipeline made a payment and suddenly everybody can get their money back. So you go ahead and you make the payment. I think that is probably, no company in America should rely upon that. My own assessment is that, there's about $10 million maybe in all the ransom payments that have ever been made that the US government has ever recovered. And I believe hundreds of millions, if not, over $1 billion has actually been paid. So like, if you think you're going to be part of that 10 million, it's just not realistic to think that. So I just, that has happened in the last year. We've had lots of clients that have thought that by making the payment, they could then get the money back. But I don't think you should rely upon that when making that. And then sort of the third big ransomware or change that we've really seen is so often it's not actually ransomware. A lot of folks don't understand ransom versus ransomware. Ransomware is when someone takes over your entire network or a portion of it and locks you out of it. That's a ransomware attack. What we're now seeing is threat actors who just gain access to confidential information and then use that to extort a payment from a company by threatening to disclose it, threatening to contact your customers or publish it on the internet. Those ransom, and so it's not that they've locked up your network, you still have complete access to it. It's just they now have some confidential information. And they're not actually trying to just get information that has social security numbers in it. They're well beyond that. They want your trade secrets, right? They want something that you're really going to feel the pain if they publish and your competitors can observe it, or nation states can observe it and then use it against you. And so that's kind of the big evolution that has happened over the last years. Much more ransom demands than ransomware attacks are still happening, but ransom demands are happening way more than the ransomware attacks themselves.
You know, Travis, that raises the point that others may not be aware of the incident that Travis is referring to, but in the Colonial Pipeline case, somehow, by some traditional, some process under the Fourth Amendment, the FBI was able to get the key to the crypto key to the blockchain account that held the ransomware. And once the FBI had the key to that ransomware account where the money was sitting, basically the FBI was able to initiate a transfer of the money to the US Treasury. It's, as Travis suggests, it's going to be the very rare case where the government, through whatever search and seizure authority it may be exercising, is able to get into the bad guy's system to that extent in order to be able to grab that key and basically use it to unlock the cryptocurrency. We are seeing another trend here, and part of the answer, a tiny part maybe systemically, but we are seeing really innovative, really aggressive action by the US Department of Justice, using remote search authorities under Rule 41 of the Federal Rules of Criminal Procedure. Just yesterday, I guess it was, the FBI announced another operation where they basically got an order, there were two orders from two federal judges, to go into computers that a GRU, a Russian military intelligence unit known as Sandworm, or dubbed Sandworm, had, the Russian group had planted malware in a variety of computers, and the FBI, this is remarkable to me, using court warrants, went into those computers of innocent victims, unwitting victims, didn't even know they were compromised, went into those computers and removed the malware. Remarkably inventive use of technology, remarkably inventive use of the Fourth Amendment in Rule 41. But again, you can't rely upon that to protect you. That's always going to be a small part of the government's arsenal.
Let me, I want to ask a question around how, and maybe Alicia, I'll start with you, since you interface a lot with Salesforce's security, engineering, and operations teams. Any practice tips for how lawyers can effectively engage the engineering and more technical side of the organization? Because all of these legal problems have some, implementation or artifact or implication for how these engineering teams build products, protect systems. How do you approach that relationship and engagement imperative?
That's a great question. So something we talk a lot about, and engineers are used to talking about, are requirements. So they build and code toward engineering requirements. That's how they sort of get all of the engineering teams, which are called Scrum teams, marching sort of to the same tune so that the build is appropriate. And so they've got engineering requirements, and really having a conversation about compliance and with regulatory frameworks being an aspect of the engineering requirements. And our teams are trained, and we can have an ongoing conversation about embedding compliance. And so it's one of the things that they build to, if you will. And we talk about it and embed it as a requirement, an engineering requirement. And so my teams push me all the time. They'll say, okay, what's the definition of done? How do we become compliant? And so I'll say, going back to the sanctions conversation, I say we cannot do business with these Russian entities on this list. And they'll say, okay, well, what does that mean? Well, because we're not going to unplug them. And we talk about IP blocking. Well, that's not very effective. They were up in arms about that being sort of the start and end. They were like, that's not going to work. You can just get around that. And then, okay, what can we do on top of that? So really, it's a partnership. And I love to geek out with them. And they're trained to, again, code to spec. And that's how I would describe it, building it into the engineering requirements.
Got it.
And I think what Alicia's talking about there is, to my mind, where we do have to go with federal regulatory policy, that there has to be, in a way, this is why I liked the HIPAA security or safeguards rule. It's outdated in some ways, but it had things you must do and then things you must consider. It had sort of three categories, but basically there was a certain baseline set of things. I don't see how anybody could claim to have an adequate cybersecurity program without having a patch management structure. I think the FTC has made it clear that for data or systems that are sensitive, multi-factor authentication is now basically a must. Encryption of sensitive data at rest or in motion. I think there are certain things that are absolute, that should be required, and required sort of horizontally across sectors. And then you have other things that a company must consider. And you can quibble. You might say, no, encryption is not reasonable or practical for some applications. So instead, you need to put that in the consider bucket and then have a good reason if you don't do it. But I think that's where we need to move. I think there's a recognition of that in Washington, at least, that's where we need to move. We haven't mentioned California yet, but it'll be interesting to see what the new California regulatory authority, the Privacy Protection Agency, which has a huge, huge agenda and a huge list of questions, but they include cybersecurity. But I think that that's really where I want the regulators to move. Things that then can be translated to engineering requirements, that can be translated to the engineers at the design phase. Some things you must do, other things that you at least need to consider and either do or not do, but have a good reason or have some compensating control if you decide not to do them. And by the way, I don't think that's something Congress can do. Yeah. I just don't see that this is, my advice would be to Congress, don't even try. Just make sure that the various agencies have the authority in their organic statutes. Some do, some don't. You could clarify the regulatory authority of the agencies, but at the end of the day, you're going to need to have, Congress can't really write these rules.
Yeah. I mean, my concern, Jim, about writing in technical requirements at the granular level of like multi-factor authentication is that security challenges and the way and the technology that we have available to secure access to systems is evolving.
Yeah.
And multi-factor authentication today makes sense. I don't know that if we have to project out 20 years.
Oh, fair enough. Absolutely.
Multi-factor authentication makes sense.
Yeah.
And so my concern is that we're kind of writing in so many of these standards today and assuming that they are perpetually going to be reasonable. And that's just not the case. And so, as between sort of the granularity that we're seeing in some consent orders of getting down to this here, and something more like the NIST cybersecurity,
right.
standard, which allows frameworks. I feel as if there's a level right above where we're seeing in some of the orders that are coming out, which is where the government needs to be, that will hopefully withstand some time. Whatever we put out needs to withstand some substantial amount of time, and it needs to be able to be revised pretty easily, which means your indication that Congress couldn't do is probably right, because it takes too long to actually pass a law.
Right.
And if you can pass it at all, and we're going to have to be more nimble. We're going to have to move quicker and to adapt to the environment. I think what the FTC is going to see is that in 10 years, or maybe even 5 years, they're going to have to start to rewrite these orders that they did 5 years ago, because they're going to come back and they're going to say, you're putting people at risk by forcing us to do this, which made sense in 2022. In 2027, it doesn't. And now it's actually jeopardizing privacy and security. And so we're going to see, we need a process to iterate on whatever standards we come around, and to do it quickly.
100% agree. No doubt. We've got to hit, though, that sweet spot, right, Travis, between the immediate certainty that can be translated into the engineering requirements, so people actually know how good is good enough. When do I reach that reason? I've now, for today, I'm reasonable. I've got there. But with that flexibility and that ability to change over time as the technology and the threats change. Absolutely. But right now, I mean, we all have to agree we're not doing a good job of that, because we don't have either. We don't have either the clarity or the flexibility.
Yeah, and I'll add, I think in my experience, with debates now going back 12 years around, the right mix of sort of market-oriented measures to encourage appropriate risk management versus mandated measurements or requirements. This critique about, well, things change too fast and government can never keep up. Look, I think there's obviously a kernel of truth to that, but too often the debate just ends there, right? And and it's used. It's why I appreciate Travis's point about trying to find something, a layer that's maybe a level above, thou shalt have multi-factor authentication, and then the NIST framework, which is so general that, right, I mean, an organization could just read the framework and assert, I comply with the framework. You'd be hard pressed to disagree with them. And so I just, I think this debate about reasonable, I think, is a very healthy development, because it's going to force us to, reasonableness by its nature evolves, right? It changes. And it forces us to think about how not only to sort of adapt rules and standards of conduct to changing circumstances, but to how to ensure that our institutions can also adapt and keep up in a changing world.
Andy, we're reaching the top of the hour. I see one question here on the March 9 executive order on ensuring responsible development of digital assets. The answer is I don't know. I'll take a look at that. And then a great comment from Len Kennedy, who has deep experience. Travis, you probably know Len from FCC days. Len says, NIST system requirements or better should be baseline and be iterated with experienced sectoral agency insights and FCC oversight. In a way that's, I think Len is summarizing what at least I'm saying.
Mm-hmm. Yeah, and I think it was what you were hearing from me about, we need some amount of coordination across them. And if it's going to be that NIST gets to set it and then everyone else adapts to that, then that's a way to do it. But some amount of coordination needs to happen.
Yeah.
Well, we are at the top of the hour. I want to offer if anybody has any last kind of parting words of wisdom for our attendees.
Just big thanks for me to Alicia and Travis. Really great, guys. Thanks so much for doing this.
Thank you so much for having us.
Great. Well, thank you all for your time. I've learned a lot, and I look forward to continuing the conversation.